Hello and welcome. My name is Brian York. This is for EDU 503 at William Woods, Sports Law. This is our Week 7 case study that is due the 14th of August 2022, and the case I am using is Jackson versus the Birmingham Board of Education. The background for this case: Roderick Jackson was hired to teach physical education and coach the high school girls basketball team in the summer of 1993. He was then transferred to a different high school in the summer of 1999. When he got there, he quickly recognized that the girls' programs were not treated equally. They were not receiving equal funding from the school. They were not given equal access to facilities. They were not given equal access to equipment, and this made it difficult for him to do his job. In December of 2000, he began complaining to his supervisor with no change. He continued to complain, and he began receiving negative work evaluations and was ultimately replaced as the girls' head basketball coach in May of 2001. As of 2005, he was still teaching PE at Inslee High School. After his termination as coach, not as PE teacher, but after his termination as coach, he filed suit in the United States District Court for the Northern District of Alabama. In terms of where the case is as we bring it here, Roderick Jackson again is suing the Birmingham, Alabama Board of Education, alleging that he was removed as coach in retaliation for complaining about sex discrimination, Title IX violation in the high school's athletics program. The United States District Court of Northern Alabama dismissed his complaint on the grounds that Title IX does not prohibit retaliation. He appealed. The Court of Appeals for the 11th Circuit Court affirmed the District Court's ruling, and the case has now reached the United States Supreme Court. The arguments of the case: Mr. Jackson alleged that the board violated Title IX by retaliating against him for protesting the discrimination against the girls' basketball team. The board moved to dismiss the case because Title IX does not include claims of retaliation. The district court agreed and dismissed the case on that argument. The Court of Appeals for the 11th Circuit Court again upheld that dismissal. They saw the fact of Alexander v. Sandoval decision that does not create a private cause of action for retaliation, and also because even if there was a case for retaliation, he has no action due to the fact that he is not in the protected class, being not female, of Title IX. The board also argued that they should not be held liable because since Title IX does not expressly prohibit retaliation, there was no way of them knowing that they were breaking a condition of Title IX when they accepted the federal money by retaliation. Basically what they're saying is since retaliation isn't in the law, they didn't know they were breaking the law. As the Supreme Court looked to make a decision, they looked at case law. Cases like Franklin versus Gwinnett County Public Schools, Gebser versus Lago Vista Independent School District, and Davis versus the Monroe County Board of Education. Again, these are cases we're familiar with through this course. These three cases all show that private parties can seek monetary compensation, in other words, money reward, for intentional violations of Title IX, including sex discrimination and deliberate indifference to that sexual discrimination. And through this case, they also talk about how retaliation must be intentional because the very definition of retaliation means I'm getting you back for something you have done. So again, it must be intentional, and it is tied to the sex discrimination and Title IX. One other thing that came through that case law was Sullivan versus Little Hunting Park Incorporated, where in 1969, 3 years before Title IX, Sullivan owned property that had a private park attached to it, and access to that private park was limited to the people that owned that property. He leased it to a black man. He transferred that access to that black man, and then he was refused access to the private park by the other owners on the property. Sullivan spoke up for his tenant and then he was expelled from the property and his shares were taken from him. Sullivan sued the property and won, again, as an advocate speaking up for those discriminated against. Since this was 3 years before Title IX, it is assumed that Congress would assume that allies and people who speak up for those whose rights have been taken away would be afforded those same rights as well. Without this, many people wouldn't speak up. I'll be honest, a lot of people, if they thought that their defending someone who was wronged would cause them harm, a lot of people might not speak up for those who are harmed. So this case law is extremely important. This case was not being appealed on whether or not Mr. Jackson was retaliated against, just if he was able to bring the case to court, because to this point it had been just thrown out based on the fact that the court said that he did not have a case to bring. Now, the United States Supreme Court found that he did have a right to bring this case, and he would now have the ability to present his evidence that he was fired as a coach in an act of retaliation based on his complaints about the Title IX violations. What I take from this is similar to what I have taken from most of the cases throughout this course. If you see something that's wrong, speak up. If you hear something is wrong, find out, speak up, help take charge, and help take care of it to make it right. If you don't do something or say something, if you try to sweep it under the rug, if you try to ignore it, you can be held liable in a court of law. Along these same lines, we, as athletic directors, cannot claim ignorance. We must do regular evaluations of our students in the school, our athletes that come out to our sports, and our coaching staff to make sure that we are compliant with Title IX. Are we offering what the students want? Are we offering it to them in a way that they want to participate? Are the coaches people that can relate to our student athletes? Can they relate to the backgrounds of our student athletes? Do they look like our student athletes? It's also just a good practice to make sure that we're meeting the needs of our student body, both academically and athletically.